So thank you for joining us. Welcome back to our returning listeners, and greetings if you're just finding us. Thanks for joining. This is Amplified Wealth According to Plan. I am Kate Fishbein, and I am here with my co-host Tom Farrell.
Thank you, Kate.
Yeah, and today we've got, I think, a topic that can sting for many individuals, right? All these changes, in the Secure Act. Beneficiaries, sometimes their head's spinning, with all these changes and how to react. And especially, after losing a loved one, it's already a challenging period. And then to have this maze of options to kind of work through and all these changes can be a challenge. So we're hoping to help some, navigate some people through this, today.
Yeah, I think maze is a good word. Would you describe what Congress did when they created this Secure Act, both iterations over the last couple of years, as an effort to help retirees? Or I think that was, there was some foundation to that in terms of trying to improve some of the, myriad of retirement laws that are on the books. But I think when you take a look at what we're going to talk about today there's a lot of rules, and you need a lot of guidance to figure out, okay, what's my next step? What's the most optimal solution for me?
Definitely. And I would agree with your statement. I do think that their intent was, was well intended to, improve options for individuals, but it has come with greater complexity. So I think that's really the challenge of kind of getting through a lot of this stuff. And, so again, these new rules, right, is really only going to apply. So again, this was, Secure Act. So to deaths and starting in 2020 and after. So it's not retroactive, right? So I think that's a really good point. So if you had a loved one pass in 2019, these updates, may or may not apply, right? So
right. Yeah. If you've really been dealing with an inherited IRA, for example, prior to the Secure Act becoming law, then, they really didn't mess up those rules. And essentially, if you've been taking distributions from those accounts, then you'll just continue on that path moving forward.
Right. And I think for today's purpose, of our discussion here, if someone obviously had passed a while back, you're pretty much probably already handling those RMDs and, have gotten the assets over and all that. So another big change is this whole category of beneficiaries, right?
Yeah. You need to know what bucket you're going to fall into.
Yeah. And that was a big change. So figuring out, what type of beneficiary are you is going to help dictate some of your options. So that's a big...
Yeah, we'll talk about some of those details.
Yep. And then there's this new 10-year rule. Because...
Yeah, I would say that the 10-year rule has been the big question mark over the last couple of years. And, the interesting thing is that they passed this law, and it applies from 2020 forward. And we're sitting here in the fourth quarter of 2024, and the IRS has continued to kind of kick the can down the road, because the way they wrote the law, there was a lot of confusion in terms of what the 10-year rule actually meant for certain beneficiaries, what kind of distributions were required, if any, during that particular period. And so, IRS continued to kind of have to issue out these notices over the last couple of years saying, hey, listen, we know things are confusing. There's nothing you need to do right now. We will update you once we finally figure this all out and have some final regulations. So, a lot of time has passed, and that's one of the things we want to talk about today is, what do you do now? What bucket do you fall into? How does this 10-year rule impact you depending on what kind of beneficiary you are, and also some of the details in terms of the age of the original account owner.
Yeah. And that's a great point, because so much time has passed, right? And I think everyone's kind of gotten used to this IRS waiver for those impacted. So, make note that, these rule changes, action might need to be taken for certain beneficiaries coming up. And then, so let's go through these different beneficiary categories. So there's now 3 categories, right?
So, so the big 3 are really eligible and non-eligible designated beneficiaries. So think about this as if you name a person, a human, as a beneficiary of your retirement account, that's a designated beneficiary. Now, the eligible versus the ineligible comes into play in terms of who that beneficiary is to the account owner. Okay. And there's going to be different rules that we'll walk through today if you are an eligible designated beneficiary. And, spoiler alert, eligible designated beneficiaries are the ones that can still enjoy the most latitude when it comes to the choices they can make with what they're going to do with that IRA once that original account owner passes. The non-eligible designated beneficiaries, this is really going to be the category where that 10-year rule will kick in. And we'll talk about some of the final regulations that the IRS has come out to provide clarity on what investors can do with that over the next 10 years as they have to distribute those accounts. And then non-designated beneficiaries, think of that as if nobody was named, the estate could be a beneficiary, a charity could be a beneficiary. Again, not a human beneficiary, and that would be a totally separate category.
Right. So kind of like estates, charities, not a see-through trust, but maybe certain trusts, that kind of thing.
That's right.
And for the purposes of our conversation, we're not going to really focus on that. We're really going to focus on more of the designated beneficiaries today, both eligible and non-eligible. So there's lots of eligible ones. So Kate, why don't we just kind of walk through what eligible designated. Yeah, I'm going to say that this whole time today. Let's call it EDB for short. That's even hard to say.
Thank you, IRS.
So, and yeah, I'm happy to walk you through these. And again, so it's not just who you are, but it could be, surviving spouse, right? So a surviving spouse is an eligible designated beneficiary. A minor child, so a child who is under the age of 21 is an eligible designated beneficiary, but please note that upon that child turning 21, they actually become a designated beneficiary, a non-eligible designated beneficiary. A disabled individual is an eligible designated beneficiary, as well as a chronically ill individual. And then someone who, it might not necessarily be someone related to you, but someone who is not more than 10 years younger than the decedent could be an eligible designated beneficiary as well. And as Tom mentioned, a lot of times these individuals will get a more preferential, option, we should say, in terms of how the assets can go.
And just a quick comment on the disabled and chronically ill beneficiaries. There are rules in terms of how to define those categories. We're not going to get into that today, but if you're wondering, what qualifies in those categories, there is stipulated definitions in terms of what constitutes somebody who's disabled in the eyes of the government, and also somebody who's chronically ill.
Yeah, that's a great point, for sure. So making sure to review kind of what's required there to be considered one of those, individuals. And then there's the non-eligible designated beneficiaries. So most likely, right? Mm-hmm. So these are non-spouse beneficiaries that are usually more than 10 years younger than the decedent. So most commonly, adult children, right? Or maybe extended family, someone that's more than 10 years younger would be considered a non-eligible designated beneficiary. And then just to further complicate things, right? The Secure Act, then another factor that we need to consider. So it's not just what type of beneficiary you are, but whether or not the decedent has started their required beginning date to factor not, what type of options are available to you as a beneficiary. Because not just determining what type of beneficiary that you are was hard enough. Now you've got to figure out if the decedent was, on or after their required begin date or before their required begin date. So what is the required begin date, Tom?
So let's walk through this. The Secure Act also has continued to move the goalpost out on the required beginning date. And so if you think about, what most people have been used to for a very long period of time before the Secure Act came along was it was age 70 and a half, right? That was the magical number for when RMDs would typically begin. And technically speaking, the required beginning date is a term associated with when required minimum distributions must begin. And when is that? Well, in order to add another wrinkle, right, to every law that we have on the books, it's technically it's April 1st of the year after you reach that designated age, right? So historically speaking, it would be April 1st following the year you turned 70 and a half. Okay. And so Secure Act, in an effort to recognize, people living longer, right? Life expectancies have been extended, a lot more longevity risk out there. They first moved the goalpost out and changed the that required beginning date, what they're calling now the applicable age. And they're using that term now because depending on when you're born, that applicable age is going to be different. And so it's age 72 for folks that are born before 1951. And if you were already taking RMDs before they changed the law, you were in that age 70 and a half boat, right? And you'll continue, there's no changes for you. You'll continue to take RMDs accordingly. Then they said, if you were born between the years 1951 and 1959, your applicable age is age 73.
And I remember that change came out like December 29th, right?
Yes.
Right before. I remember all the custodians had to scramble with that that update for sure. Just to
and there
keep
was a lot of questions too about there was and there was even they made a mistake in the actual text of the law where there was some questions about people that were born specifically in 1959. The way they wrote it, it looked like somebody who was born in 1959 could either have an applicable age of 73 or 75. And so then, a lot of practitioners had to go back when they submitted comments about the new changes. They needed clarity on that. So they did come back and clarify that if you were born in 1959, your applicable age is now 73. Anybody born after 1959, 1960 or later, that new applicable age is 75. So again, depending on how, what year you were born, this required beginning date, again, it's always April 1st after that age that we're listing on the page here.
Right. So for example, if I was turning 73 in, let's say May of 2025, my RBD date would be April 1st of 2026, hypothetically.
That's right. And what does that actually mean? Well, it means that in that very first time you have to take your RMD, and it only applies to that very first time. It means that the latest you can take it is April 1st of that year following the year you turn the applicable age. But then subsequently, it needs to be taken by December 31st of every year, right? So in your example, right, if you don't turn the applicable age until, 2026 or so, you could say, you know what, I'm not going to take my RMD in 2025, which I could, right? I'll delay and I'll take it in the first, 3 months of 2026. But then I got to take my second RMD by the end of December of the same year, in which case you may be doubling up. But again,
and it's almost like they give you like a little grace period in a way, right?
Yeah.
It's like first like when you're first getting started, like here's a little grace period, just, so you get the hang of it. But yeah, you're right. Then you get hit with two, taxable distributions. Because remember, anything that's coming out of a pre-tax IRA, is going to come out at ordinary income, right? So
that's right. And it just, I think this highlights the layers involved when you're looking at, a lot of the laws that are written, in Congress. There's a lot of if this, then that, right? And that kind of adds to the complexity, which highlights, I think, a lot of our conversation today. And also back to this whole non-eligible designated beneficiary who are subject to the 10-year rule. The big question over the last couple of years is, do I have to take minimum distributions during the 10-year period, right? And there wasn't an answer to that until now.
It's taken a long time to get that kind of final regulation, and we got it. For better or worse, we got it. So
now we know.
Yeah. So let's talk about this 10-year rule. So as you mentioned, this is kind of, one of those things we just got some clarity on. And this 10-year rule applies largely to those non-eligible designated beneficiaries, right? And the clarification is mentioned. So you have to figure out, what type of beneficiary you are. And then, of course, did the decedent pass on or after their required beginning date or before their required beginning date? Because different rules will apply. So this particular rule, again, largely to non-eligible designated beneficiaries. And so what this rule says, so if the decedent had passed before the required beginning date, no required minimum distributions will be due each year but the account needs to be emptied by the end of the 10th year. And remember, anything coming out of pre-tax, IRA account is going to be, taxed as ordinary income. Then the 10-year rule says, well, if the account owner or, the decedent had passed on or after their required beginning date, RMDs are due during each year during this 10-year period, and the account must be emptied by the end of the 10th year. And so I think that's the big change for a lot of people. So we'll talk more about that as well.
Yeah, I think the thinking, just real quick on that point, and by the way, when you just mentioned this category of beneficiary, it just kind of rolled right off the tongue. That was probably our best one so far.
Was that good?
Of today's discussion.
Right.
And so what was I going to say? Oh, so, the RMD rule, right? That the way that I've heard some people talk about this is, essentially it makes sense if you think about it in this kind of way. If the original account owner was already making or taking RMDs, right? Then there's no way to stop it. The beneficiary needs to continue to take those distributions, right? It's once you start, you kind of can't stop type of thinking, right?
Right.
Which is what they applied to this, and the way they wrote it is on or after, meaning that somebody, would have been or should have been taking their RMD. And so therefore the beneficiary must continue to do the same.
Right. And of course, in that year that the decedent passed, it is, remember too, if that decedent has been taking required minimum distributions, you also have to fulfill the decedent's required minimum distribution before, moving the funds into your inherited IRA. And then that's where, you'll be then required to start taking required minimum distributions each year and then emptying the account, in that 10-year period.
Oh, yeah, that's a good point. I mean, because sometimes people take their RMDs like on a monthly basis, right? So if they die in the middle of the year, then, they might have 6 more months left of an RMD that needs to be taken that wasn't before death. So
yeah.
That's a good point.
And a lot of times clients will just take it at the end of the year too, right? Just right. Letting, if they don't need the funds, just let it earn some tax-free interest, during the year. Why not? And then, again, so kind of like this 10-year period. So you've got the year that the decedent passes, and then the 10-year clock starts that next year. So time starts up right after the year that the decedent passes.
Yeah. Do we have a slide on? Yeah, I think on this one we talk about a little bit more about that 10-year period.
Yeah, and I think it's helpful to see it visually too for our, the folks tuning in on YouTube if you can. But we'll walk you through this chart as well. So this whole, this is a big change because as we were saying, so much time passed and IRS had issued waivers for required minimum distributions starting in 2021. And then it was, 2022, 2023, and now 24. But starting next year in 2025, these RMDs for inherited IRAs where they're going to be impacted by this 10-year rule and the decedent had started taking required minimum distributions or, on or after their RBD date, this is going to start kicking in 2025 where that, there could be potential penalties because remember, there are penalties for not taking those RMDs.
That's right. So I think the important thing here is, at least in terms of this visual, what we're trying to show here is that, for somebody, for example, that passed away in 2020, that 10-year clock started in 2021. And so if you've done nothing in terms of make distributions over the course of the last 3 years, then now your window is down to 7 years to make distributions rather than a full decade. And so, why does that matter? Well, to your point earlier, Kate, right? A lot of times we're talking about pre-tax IRAs, which means that every dollar that comes out is subject to ordinary income tax. And so, if you have the ability to kind of smooth that out over the course of several years, rather than waiting, let's say you could wait to the end if you wanted to, right? That's your choice. But that means that in that last year, you make that lump sum distribution, and now you have a huge tax hit, right? You might call it like a tax bomb, right? We were chatting about the other day.
Definitely, love that term.
Probably not the best solution, and because now we have guidance and it's still 2024, there's still time to act this year before we get to the end of the calendar year to make a distribution and plan for the next, several years until that 10-year window is over.
Yeah. And this is definitely something that we would advise, that individuals work with their different tax planners. A lot of times, people are inheriting these funds, sometimes at the peak earning years, right? Where, mom and dad pass away and they leave you maybe a nice IRA account, but, you're in your high earning years, and this could, any of these distributions really could push you up into another bracket. So really trying to, plan and consider is warranted for sure. And then there are spousal bennies.
Yeah, let's get really complicated now.
I know it's so funny because it's like the non-eligible designated beneficiaries. I think we've had a lot of those rules, but that clarification surrounding the required minimum distribution is what everyone was waiting for, and now we've got some additional layers within spousal beneficiaries.
Yeah, and let's just start by again reiterating that most of the preferential benefits go towards eligible designated beneficiaries, and most of those are typically spouses, right? So the good news is that spouses still get to enjoy a lot of the special treatment, right? But again, based on the fact pattern of every particular situation, there's going to be choices that spouses make in order to, optimize the results, right, of their particular situation.
Definitely. And each situation is so unique. So ultimately, reviewing with your tax professionals, financial professionals, attorney might be, warranted for sure. But more or less, there's two options, right? For a spouse inheriting funds, right? Spousal rollover or the inherited IRA. And there are different considerations, with each of those options, and potentially, different distribution rules as well.
Yeah, and those were available before they changed the rules with the Secure Act, right? So spouses, before they changed the law, still could go the inherited IRA route. They could still roll it over to their own IRA. Secure Act added basically another option for spouses, which does add to some of the confusion. But I think the effort from Congress was to try to make things a little easier for spousal beneficiaries when it comes to distributions down the road, which is welcome for sure. I think just some of the confusion lies in the details in terms of how you do it, when you should do it, what it means. What are your options down the road? If you make one decision today, can you make another decision down the road? Right.
Right. Is it irrevocable?
Exactly.
Yeah. And each option has different considerations and different rules, of course.
So you want to start with the left-hand side of this page here, the inherited IRA version?
Let's start there. We'll read left to right.
All right. So let's talk post-Secure Act. So post-Secure Act, inherited IRA, this is an option for spousal beneficiaries where if you don't want to roll your deceased spouse's IRA, if you were the sole beneficiary, if you don't want to roll that to your own IRA, which you can do, you can leave it as an inherited IRA. You're the beneficiary. And there's certain, benefits to that. So let's just chat about some of those. Number one would be an inherited IRA is not subject to the early distribution penalty that regular IRAs are. And so I know you and I were chatting about that recently, and this is the 10% penalty if you're under age 59 and a half.
Right. So it's huge. So let's say, I'm a younger spouse, and I need access to funds. If I were to roll the account into my own IRA account, do that spousal rollover, you might get hit with that early withdrawal penalty. But this inherited IRA option, because there aren't early withdrawal penalties, you do not get hit with that early withdrawal. So if I was someone that needed access to the funds for living expenses, this might be a potentially good option.
And historically, that's been, a nice way for you to avoid, that unwelcome penalty situation. And then, once you were older than 59 and a half, you could always just roll that IRA to your own.
Yeah. And one thing to note, though, because one of the benefits of doing kind of that spousal rollover is that you can make contributions as well, right? Where this inherited IRA option, you cannot make contributions to this inherited IRA.
Yeah. So again, this kind of highlights, if this, then, right, what does it mean for me if I chose this particular, route? And what does it mean for me now, depending on how old I am, what my cash flow needs are, and things like that. But then, we also need to think about what does it mean for, required minimum distributions down the road.
Definitely. And there were some recent changes there, right? That's kind of where some of these big changes in terms of the options and whatnot have come.
Yeah, so we have a little box on the left-hand side that talks about this new Section 327 election, and this has also been a confusing topic for a lot of IRA owners out there to try to figure out what does this mean for me under the new law. And essentially, this goes back to my point before about Congress trying to help with beneficiaries in terms of what the distribution rules look like. So before they changed the law, if you were a spouse and you went down the inherited IRA route and you left it in the inherited IRA, when it came time to making distributions, you were subject to, there's a few different life expectancy tables that the IRS requires IRA owners to use in order to make those mandatory distributions at, later in life when you reach your applicable age.
Right. And it depends on if they just, died before or on or after the RBD date as to what table you're going to use.
Right. So when do I make them? What table do I use? When you think about it, actually, it's, if you don't know a lot about these rules, it can be really, really easy to mess up, right? Use the wrong table, not make the distribution in time, use the wrong person's life expectancy. So it's really important that you're asking questions in terms of, what might apply to your situation, and try to get some guidance on, some plan of action, that would make sense.
Right. And net, these eligible designated beneficiaries do have that more preferential ability to kind of stretch these funds over their lifetime. Obviously, the particular RMD rules are going to depend on various factors, but still you have that stretch ability, which the non-eligible designated beneficiaries do not have anymore post-Secure Act.
Yeah, and that's been people talk about this whole stretch IRA. Oh, what's that? What's a stretch IRA?
It sounds great. Yeah.
Right. And it's not really a different type of an IRA. It's just the ability to essentially stretch future distributions according to a life expectancy rather than, let's say, like a 5-year period or a 10-year period. Right. And so, we have this little stretch lives box at the bottom. And it kind of came to me. I was thinking about Fletch, that movie, that old movie, Fletch Lives. And so, for spousal beneficiaries, eligible designated beneficiaries, you still get to stretch, which from a tax standpoint is beneficial, right? You don't have to condense your distribution to a shorter period of time, which typically would result in a higher tax bill. Here, if you don't need the money, you can stick to the minimum distribution and only pay tax on what has to come out.
Right. And of course, there's those different IRS tables, publication 590B. So a lot of, complications, which
is that where you're going
to
are you going to read that on your flight across the pond?
I actually have a 590B printout somewhere on my desk. Yeah,
I think if you're going to reference that, you have to read that. Yeah.
Well, if I'm having difficulty sleeping, that might prove helpful for sure.
But just one last comment here on Section 327. It's essentially going to allow surviving spouses to use a more favorable life expectancy table published by the IRS, which means it results in smaller mandatory distributions down the road, which is good, right? That's essentially what most folks want. for their distribution strategy. And right now, as far as I know, Kate, from everything I've read and folks that I've talked to in this space, it's if the original account owner died before required beginning date, then the surviving spouse is basically automatically deemed to have already elected 327, right?
That is my understanding.
And if the IRA owner dies on or after the required beginning date, then it seems that a surviving spouse beneficiary would need to make this election. I'm not 100% clear on when and how that election gets made. One of the things that we've been talking about, obviously, is IRAs, right? But this really, applies to retirement accounts, which could include, a 401k. And from a plan administrator standpoint, right? The folks at companies who are administering 401k plans on behalf of their employees, the way the law works is that those plan administrators can decide to apply their own rules for their beneficiaries, right? Because, at the end of the day, a lot of times they don't want to have to deal with 100 different rules for beneficiaries, right? So a lot of admin work for them, and they want to try to simplify the process as much as possible. So essentially, plans could say, hey, if you're a surviving spouse and you're listed as the beneficiary, here's our rule for you, right? And you got to walk down this road depending on what the plan document says. So I think there's going to be some updates over the next, couple of years or so in terms of plan documents and what these plan administrators need to, to build into their decision making.
Yeah, and really the recommendation is, if you're inheriting 401k assets or whatnot, really you've got to contact the plan administrator, because a lot of these rules might be very different considering what the plan has dictated as your options.
Exactly.
Right. Just to further complicate things.
Yeah.
Right. So,
I'll say, because we're talking about folks that are involved with like the operation of the account, right? 401k, you're talking about, the plan sponsors and, the third party vendors that help with that. And then even when it comes to an IRA, you're not really going to get help from the custodian on this, right? It's not as straightforward as a regular RMD for somebody who's still living and owns their IRA, right? There's pretty clear laws on that. And we're actually seeing that listed on statements, right? So, they look at the prior year end balance. And then if you take a look at your statement and you're already in RMD age, your statement will show, here's how much your RMD is for this year, right? That's pretty clear. But custodians are saying, hey, listen, because of the complications with inherited IRAs, we're not giving guidance on that, and you're likely not going to see any kind of figures on a statement either.
Yeah, and in their defense, I feel like that's always been their stance, Tom, right? That because it always has been a more complicated calculation, and there could be different variations. So they've always steered clear, and because it really does fall under more of a tax type of umbrella. So let's talk about spousal rollover option for a sec. So this is where essentially, the decedent leaves the IRA, and the sole beneficiary is the spouse. The spouse has the option essentially to treat these funds exactly as if they were their own. So they could either roll over these IRA assets into an existing traditional IRA account that they have, or open up a new IRA account in just their name and essentially treat these assets that from their deceased spouse as their own. And that could also give them some benefits. Kind of using that more preferential, table for the IRS is always a benefit as well, right? And then again, since it's their own IRA account, if they have earned income, they can make contributions. But if they need to withdraw funds and they're younger than 59 and a half, you've got to watch out for that early withdrawal penalty, with this option.
Yeah, so timing plays a role in the spousal rollover. And the good news is that there's as far as we know, there's no timeline on when you can choose to move from an inherited IRA. If you're that sole spouse beneficiary and you start with an inherited IRA and then roll it over to your own IRA at some point in the future, that's still your obligation to do if that makes sense for your situation. So, you also get to name your own beneficiaries, right? So a lot of folks are trying to make decisions in terms of, okay, well, who gets this money after I pass, right? And that's a big decision as well.
And that's a great point. Yeah. So there could be some more preferential beneficiary treatment if you do that spousal rollover. Let's say, you remarry, you do that spousal rollover, you have the IRA assets in your name alone, and you put your new spouse on that IRA account, you might have more preferential treatment for the beneficiaries. So why don't we walk through some examples?
Sounds good.
Because there's a lot here. So maybe walking through kind of a hypothetical case will help our listeners.
All right.
So let's walk through an eligible designated beneficiary example for a spouse. So we have dear Peter, he is 71, and Peggy, who's 70, are married. Unfortunately, let's say Peter passes this year in 2024. And since he was 71, he was before his required beginning date. Peggy's listed as the sole beneficiary of Peter's IRA. So let's walk through. What does Peggy do? What are her options? Lead us off, Tom.
Yeah, I was going to say, I could chat about some of these if you want. So we have four main choices that Peggy can deal with here. First one is Peggy can roll Peter's IRA into her own IRA as her spousal right. And as you said before, Kate, when she does that, the assets are hers, as if she funded the account herself all these years anyway. And she's 70. She's not at her applicable age yet. RMDs would start for her when she reaches her applicable age, 73. That's in 2027. And she gets to use a favorable IRS table to make those distributions. That's one choice.
The uniform lifetime.
Right. The well-known uniform lifetime table. 3.
Which I'll be reviewing. I'll be reviewing in my publication 590B this weekend.
Right.
Yes.
But the point is, that's the good one. That's the good table to use in terms of smaller mandatory distribution per year. Right. You want to hit number 2?
I was dying to. You could tell.
I know it.
Well, option number 2 is that Peggy can treat Peter's IRA as an inherited IRA. And RMDs would be due when Peter would have reached the applicable age of 73, which would have been in 2026. And in this scenario, she would have to use that single life expectancy table, which is not as preferential because she would have potentially a larger amount that would need to come out. So you're losing that ability to kind of continue that tax deferred growth. You're having to take out more from the account.
And if anybody is a college football fan, if you watch Game Day in the morning, one of the commentators is a guy named Lee Corso, longtime coach. He's been doing the show now for years for ESPN, and he's famous for his catchphrase, "Not so fast," right? So they're all making points and predictions about who they think is going to win that particular Saturday and all these key matchups and whatnot. And they'll go across the table and everybody will talk about who they think is going to win. And somebody will make a point and then he'll say, "Not so fast." So number 3 is not so fast. I think about this as, okay, now, as per the new Secure Act edition of this Section 327 election. So Peggy can still go this inherited IRA route. And because he died before his required beginning date, she's essentially deemed to make that 327 election, which allows her to wait until, RMDs would start when he would have reached his age. But now she gets to use more favorable uniform life table instead of the single life table. So not so fast.
Not so fast.
It doesn't have to be as bad as number 2 suggests. Number 3 can be an option for Peggy.
Yeah, I feel like there needs to be a hand gesture with "not so fast" too. Like, not so fast.
Well, he's famous
doing this.
He's famous
point
for holding
thing.
a pencil. He's famous for holding a pencil and saying,
all right.
Not so fast.
Not so fast.
Yeah.
Not so fast. All right. And then number 4 is you can elect that 10-year option. And because it was before RBD date, there wouldn't be any RMDs in years 1 through 9, but then the account would have to be emptied in that 10th year. So not so fast.
Yeah.
More or less, right? So I think the best option in Peggy's situation probably is number 1. And of course, we would say, Peggy, please consult your tax advisors and make sure, and as well as, Peggy's over 59 and a half. So that early withdrawal penalty might not be an option, might not be a problem if she does have cash needs. and yet she gets to treat the assets just like they were her own and use that preferential tax table.
Yeah, we highlight this in yellow just because it seems like it's the best solution. Again, we're not giving advice during this talk today, but it just seems like based on the facts of this case and the fact that Peggy's also a year younger than Peter, which means she wouldn't get to her RBD, for another
That's
year
a great
after
point.
he would have. So it seems like that's probably the best option for Peggy.
All right, let's go through another one. And we could go through a million of these, Tom. And each answer might be different. And that just speaks to that every situation is going to be different and might warrant another solution. So
we'll get you a microphone for the plane, and you can tune in and we'll talk about every scenario that we can think of. So here's another situation. We're again talking about a spousal beneficiary, but now the ages are different. In the prior example, Peter was 70. Peggy was Peter was 71. Peggy was 70, right? So they both were not at RBD age, but they're pretty similar in age. Here, there's a bigger disparity in age. And Peter is only 68, so he's still before his required beginning date, a little bit younger. But Peggy is 77 in this example, so she's already past her required beginning date.
I gotcha. So that's going to be a key factor and one factor to consider when looking at your choices.
Right.
So Peggy's choices, let's go through this. So Peter hypothetically dies this year. Peggy's sole Benny. So Peggy's choices. I feel like that's like a movie here. Peggy's choices. All right. Number one. So because she's this sole spousal Benny, she could roll Peter's IRA into her own IRA, treat it as her own, right?
That's right.
But if she were to do that, since she's, as you pointed out, she's over the RBD age, she would have to start taking those RMDs each year based on her age, just like it were her own IRA. Or there's number two, where she could treat Peter's IRA as her inherited IRA. And then the RMDs would be due when Peter would have reached the applicable age, but she would need to take her RMD based on the less favorable single life expectancy table based on her age, which was 82 at that time, where Peter would have met his RBD age. So that probably wouldn't be the best because that divisor for 82 would be 9.9. So you're really having to take a heavy RMD from from the IRA account. So that would be a big distribution. And then you want to walk us through 3-4?
Sure. Or Peggy could treat Peter's IRA as an inherited IRA and wait to roll over to her own IRA when Peter would have turned 73 in 2029. And therefore use a uniform lifetime table at her age 82, right? So compare that to the divisor in example number 2. That was much lower. Here, the divisor for the uniform life table, again, based on her age, would be, basically almost double. And she can roll that.
That's a big deal.
Yeah, she can roll that over to her IRA at any time. So even though she's already at RMD age, really the factor here is which divisor are you using as per the IRS life expectancy tables? And that's going to matter in terms of the total value that must come out, like that minimum piece. And again, in a lot of our examples here, we're talking about traditional IRAs where these distributions are subject to ordinary income tax.
Right. Those pre-tax funds.
And then number 4, this one. So in number 2, we were saying, hey, it's kind of like the old way, leave it as an inherited IRA, but now you got to use a single life expectancy table. But she could do the 327 election in our example number 4 here. And therefore, instead of having to use a single life expectancy table, she could use a uniform life table and again, have a more favorable, i.e. lower distribution amount. So from that perspective, that's why we highlighted options 3 and 4 based on the facts of this case. Seems like that would probably be the best bet for Peggy. Again, assuming all else is kind of equal, and that she would be able to kind of manage the amount that comes out depending on the route she went down.
Gotcha. And because he was before RBD, there's that 10-year option again, but then you kind of get hit with that tax bomb, no RMDs to years 1 through 9, but then the account would have to be emptied in year 10. So
Yeah, and just a quick comment on that 10-year option for spouses. It's really not going to be a common solution from what we can tell. It is an available solution. Perhaps somebody does want to condense the distribution period. Maybe they do want to get as many dollars as they can, depending on how old they are, their personal circumstances. But and we won't spend a lot of time on this, but the IRS did think about ways that this could be abused. And the term they're using is hypothetical RMDs, where, for example, if somebody decided that if a surviving spouse decided they would elect a 10-year rule, in which case, because the person died before required beginning date, there are no RMDs required. So they could say, okay, great, I'm doing 10-year route, no distributions until the 10th year. I'll just wait until then. But, what if that same person decided not to make any distributions to years 1 through 9, and in the 10th year said, you know what, because I'm a spouse, I'm going to roll this to my own IRA, right? And again, IRS said, not so fast. If you try to do that, we will get you for all the RMDs that you should have taken if you rolled it over prior to that. And so you'd have to go through the calculations in year 1 through 9, because in this case, Peggy, she's already beyond RBD age.
Sure.
So she'd be taking RMDs anyway. And so you'd have to go back, calculate the year-end value through 1 through 9, from years 1 through 9, calculate how much of the required minimum addition would have been, and then take that before a rollover would occur. So not a viable strategy for folks. That's an abuse.
Yeah, for sure. I see why they closed that loophole, because it would be tempting to just delay taking required minimum distributions. So, and then just being able to roll it over maybe to your own IRA at that point. So I see why they closed that, why those hypothetical RMDs came into play. All right, and let's walk through a non-eligible designated beneficiary example.
Yeah, so we've been focusing a lot on spouses, but let's go back to this concept of folks that are subject to the 10-year rule. And it's going to be a lot of adult children of account owners, typically speaking, and then maybe some of that extended family that you were talking about before.
Definitely. So let's talk about Paula, who's 75, and unfortunately, Paula passes away this year. In 2024, Paula was not married, and Paula had listed her daughter, Penny, as her beneficiary. So let's go through Penny's options. So her first option would be, Paula had died after her required beginning date. So she's already begun taking her required minimum distributions, right, as another clarification here. So kind of step one for Penny would be that she would need to complete any required minimum distribution that Paula hadn't fulfilled for the calendar year that Paula had passed in. So if mom passes away mid-year and she hasn't fulfilled that required minimum distribution, Penny would have to make sure that RMD is distributed before moving the funds to that inherited IRA for Penny. And since Penny will be subject to that 10-year rule because she's a non-eligible designated beneficiary, because Penny is more than 10 years younger than Paula, and she is not Paula's spouse. She's non-eligible designated Benny, so she is subject to that 10-year rule. And so since Paula had been taking her required minimum distributions and died after her required beginning date, Penny's also subject to the annual required minimum distribution requirement, as well as she must empty the account by the end of the 10th year. So a lot going on there.
A lot going on. You really got to know the facts of the case. And you really start with who owned the account, how old were they upon death, and that will help to, point you down the road in terms of what class of beneficiary you fall into and what the rules are going to look like.
Definitely. So that's kind of, knowing when the account holder died, current and future tax brackets of the beneficiary are helpful to know too, because again, a lot of times we are looking to distribute the funds over these 10 years, and maybe it's less for someone who passed in 2020 or, between 2020 and now. looking at the brackets and when it might be, advantageous to take distributions, considering this 10-year rule. And then whether or not RMDs during this 10-year period are required or not, right? So whether or not the decedent passed before or on or after their required beginning date.
Yeah, because the IRS kicked that can down the road for several years, RMDs, as we know now, are not required until starting in 2025. And so, again, we're going to bring
someone
it back.
under this 10-year, for someone under this 10-year
under
rule.
the 10-year rule. Right. That's right. And so, we want to just bring it back to this visual we had on a previous slide. And this kind of highlights the extreme example, right? You go back to when this law first applies, right? So people that passed in 2020 and beyond. So, if somebody had died in 2020 and a non-eligible designated beneficiary, basically takes over or so, and they didn't make any distributions in 21, 22, 23 because they didn't have to, right? Right. And in 2024, the IRS said, oh, by the way, you don't have to take one this year either because we just kind of figured this all out. And so therefore, we're going to make this happen starting next year.
But there's still time. There's still time in 2024. The good news is that, the calendar hasn't turned over to January yet. And from a tax planning standpoint, the way to think about this, and we touched a little bit earlier on this, Kate, right, is I think a simple way to think about it is, smoothing out the tax hit over that 10-year period, right? And a pretty simple way to kind of think that through is to say, for example, if I got a $100,000 IRA that I inherited, perhaps I'll distribute $10,000 around that amount for the next 10 years so that I don't have one particular year that's so much larger
or so much smaller than the other. And I'll have a more predictable pattern of distributions that get added to my tax return. And that's probably going to be a pretty good bet for most of these beneficiaries that fall into this bucket. And we have a line in here about opportunistic distributions, and it could be that,
let's say you're retiring this year and you fell into this bucket of being subject to the 10-year rule and RMDs, or even just the 10-year rule. If you're going to fall into a very small or a much smaller tax bracket starting next year, then maybe you start all those distributions in 2025 and you work your way through the balance of whenever your 10-year period is going to expire. And again, it depends on when that death occurs. But for folks that passed in 2020, the end of that 10-year period is going to be 2030. So if you've done nothing, and if you still do nothing this year, then you're only going to have 6 more years left of planning for those distributions before that account has to be emptied. So probably not the best solution to wait until year 10 and make a very large distribution. Think about it as, if you retired from your 401k and you accidentally chose the lump sum distribution when you weren't planning on doing it that way. That's a big tax hit in one year. So that's probably not the best solution.
So, again, since so much time passed, right, since this legislation happened, and then for the IRS to come out with some of these final considerations, there could be a lot of situations where someone passed in 2020, 2021, 2022, 2023, where maybe the non-eligible designated beneficiaries haven't been taking required minimum distributions. But if the decedent was on or after their RBD date, they will now have to start taking these minimum distributions, and they might, starting in 2025, and they now have a smaller window to distribute the remaining funds before this remaining 10-year window, right?
Yeah, that might be the bigger point here is there's leniency on the RMD rule, right? The IRS is saying, okay, you can start next year, which is great. But when you do the math on the minimum distribution, if you just stuck to that until year 10, you're only distributing out a small portion each year, still leaving a large dollar value to be distributed in full on that 10th year. So, from a hey, let's start to figure out what a course of action should look like. The sooner you start, the better. So, just an alert here for folks that are subject to the 10-year rule and where the 10-year rule started, when your clock has started, prior to this year, you might be running out of years to effectively make distributions and have that work in terms of your overall tax plan.
The thinking here is almost like you want to spread out that tax liability a little bit more instead of creating this this tax bomb in that final year where you've got to empty out the remaining account in that final year, of that 10-year window.
Right. And that's probably going to be the best way to go, is to think about it in terms of smoothing it out. Maybe proportionally over a 10-year period. Perhaps there's an opportunity where, there's a couple of abnormally low tax years and maybe you do a little bit more in those years. But again, everybody's situation is going to be a little bit different. But generally speaking, Kate, yeah, I think you're right. Think about this more of, okay, how can I probably smooth this out over the 10-year period and just have a plan to make sure that you get that done. So that you're not running into any penalties at the end of the period or too many taxes.
Yeah, that's a great point. Because there was a situation where someone was retiring. So we're kind of planning for that retirement, to start to distribute some of the inherited IRA. Obviously, now we're going to have to be respectful of that required minimum distribution. But as well, looking for those gaps, maybe like you have a lower income year, to your point, Tom, that you can kind of fill up maybe a certain tax bracket with distributions for this, kind of 10-year planning in your head, just to kind of level things out a little.
Yeah. And depending on when that death occurred prior to this year, you may be in the 7-year rule, right? If death occurred in 2020, you could be the 8-year rule if death occurred in 2021 and so on. So that's really the way to think about that now is what do I do now?
Right. And how many years left? Forward? Exactly. So, and let's go over just some important little other, kind of closing thoughts for some of our listeners. One thing that we didn't touch on is that, one option is that when you're inheriting funds, you can take a lump sum, right? But instead.
Oh, sure. Yeah.
Right. But talk about lump sum. If it's a pre-tax, IRA, so that could be a huge tax hit. So, always put that tax hat on, for sure. And even with certain Roth accounts, there could also be tax implications depending whether or not the funds have been held, in that Roth vehicle for 5 years, and depending on age and whatnot. So more considerations, right?
Yeah. So Roth IRAs would still, if you're a non-eligible designated beneficiary, they've been in there long enough, you could still be subject to the 10-year rule. So you still got to empty out that Roth IRA, but there would be no tax, right? If that's the facts of your situation, you just got to get it out of the Roth IRA world, if you will, and move it into non-retirement accounts as per the
right.
The
and contributions to Roth IRAs always come out as tax-free. But again, for those kind of any earnings, that have, you got to watch that 5-year window too, because not all Roth IRA distributions are tax-free all the time. So you kind of got to watch yourself a little bit there.
Right. And it also highlights the opportunity to make Roth IRA conversions if it's appropriate for your situation, right? Because there are different rules for different IRAs. And so that might be another incentive if somebody's already thinking about doing Roth conversions. If you just think about the way that these distribution rules work, depending on who your beneficiaries are, could be a good idea to add some more dollars to the Roth world.
And the other thing we kind of touched on, but I think it's worth mentioning again, is that, qualified plans, they have a different rule book. So, if you're inheriting 401k assets, make sure that you're reaching out to the plan administrator and finding out what your options are for distributing the funds. Because there could be a complete different set of rules to play by.
And the age. So let's just not forget
That's a good point.
We had a slide where we talked about the applicable age. So we just wanted to be clear on, the applicable ages we talked about were, your standard applicable ages based on the year you were born. And for the most part, talking about, IRA accounts or 401ks where you're retired. If you happen to still be working and you're not a 5% or more owner of the company and you have money in a 401k, your required beginning date doesn't necessarily have to align with that age 73 or 75, right? You could still be working and could be 78 years old. And your required beginning date wouldn't occur until after
as long as you're
retired.
As long as you're not a 5% owner. Right.
That's right. Yeah. So, right. It's for those folks that kind of fit that rule framework, you need to think about this just in terms of a different kind of a paradigm. And you may also own IRA assets outside of your 401k, in which case those would be subject to these applicable ages. But your 401k, if you fit into that still working and not a 5% owner or more, then that could be a much later age, depending on how much longer you're working. So just something to think about in terms of different types of retirement accounts and what the rules look like.
It's a great point. And speaking of different retirement kind of buckets, so like if you have a required minimum distribution from your inherited IRA account, let's say I took a distribution from my traditional IRA account to fulfill my required minimum distribution, that distribution isn't going to count towards the required minimum distribution that I need to take on my inherited IRA. So they're kind of little different buckets. So you need to, be considerate of, required minimum distributions and making sure that they're coming out of the right buckets, depending on the different types of accounts. Just because I have a traditional IRA doesn't necessarily mean that I'm going to fulfill that inherited IRA required minimum distribution. And then, you got to review your overall plan, right?
Yeah. Yeah. We've walked through a lot of rules, right? A lot of, different situations depending on, the facts of the case, who owns what, how old are they, who their beneficiaries are. And, now that the Secure Act is in place, there's going to be, a set of steps that would help anybody make the optimal decision. And so, yeah, Kate, to your point, it's going to be, up to your particular situation, and what your goals and objectives look like, so that you can make a decision that meets those priorities. So, I think there's a lot that we covered here, a lot of nuance, a lot of wrinkles, a lot of layers, that really need to be considered. And I think it just highlights the fact that, folks need help with
right. And working
stuff.
with your trusted advisors, trying to navigate, this puzzle. I think is a great idea, because there is a lot to navigate, and there are a lot of, little things that you can get stuck on and trip over. So making sure that you're making the right choices and treating everything correctly.
Couldn't agree more. I think that's a great way for us to wrap this up. Kate, I hope you have a fantastic
Thank you very much.
Trip. Safe travels. Enjoy everything while you're there, and look forward to seeing
Likewise.
you when you get back.
Thanks for everyone for tuning in.
And don't forget to, if you're watching us on YouTube and you like what you're hearing and you want to hear some more, please like and subscribe on YouTube and spread the word in terms of the podcast, wherever you get your podcast.
And we'll see you here next time.
Thank you.